Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Monica presenting for us. If you are unfamiliar with the format of this event, first, Monica is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Monica will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Monica to get us started.
Good afternoon. Thank you for joining Legal Aid today. Sorry, I'm going to mute the sound on my computer because it's sounding when I get alerts, which happens all the time when I get an email. Anyway, my name is Monica Savage. I am an attorney in the Winston-Salem office with Legal Aid of North Carolina, and I am presenting on custody today. However, Legal Aid of North Carolina does provide a lot of different types of assistance to people. We're a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure equal access to justice and remove legal barriers to economic opportunity. Our main areas of practice are housing, employment, education, domestic violence, disaster relief, and consumer law. We are generally not able to represent people in custody matters, but we are so happy to be able to present this general information to you to help you in your custody matter. We have monthly listen and learns for all kinds of different areas of law: simple divorce, child custody, criminal record expunction, tenants' rights, Social Security disability, Medicaid rights, SNAP, Medicaid eligibility, and healthcare power of attorney and living wills. You can always visit our website at legalaidnc.org and go to the listen and learn section. Remember, again, as Marissa said, Legal Aid of North Carolina does not represent you in your custody matter. The point of this presentation is to give you information so that you can represent yourself. We call that pro se representation for the initial filing of custody and or visitation, applying North Carolina law only. So if you are in another state, none of what I'm telling you might apply to you. You'll need to seek out resources in your state. This listen and learn provides assistance in initiating a custody action. So if you already have a custody case pending or a custody order in place other than a temporary custody pursuant to a protective order, you need to file a motion to modify. Informations about motion to modify are available on request, but this does not cover that. This is if there's no custody action in place separately from a protective order in North Carolina, and you need to file initial custody matters regarding your minor children. The North Carolina general statutes, that's the big books of law that cover laws in North Carolina. North Carolina General Statute Section 50A speaks to child custody more specifically, and NCGS 50-13.1 speaks to child custody and mediation. Now, there are two main kinds of custody matters. There are going to be custody matters between two parents, and the legal standard for a parent against another parent is the best interest of the child. If you are not a parent, but let's say you've developed a relationship where you're taking care of the child because you're an aunt or an uncle or a grandparent, or even some other person where you've been taking care of the child a lot, you're very involved in the child's life, and you're worried about the safety of the child, the legal standard for you to prove that you should have custody is you have to first prove that the parents are unfit. So you can't just go and file for custody because you're mad at your son-in-law. You have to show that the son-in-law is an unfit parent. And if he's still with your daughter or son, then you have to show that they're both unfit parents. Um, there are some definitions, some terminology that we use in these kind of cases. There's a plaintiff, there's a defendant, pro se is another word, primary custody, visitation, legal custody, physical custody. The plaintiff is a person who files the suit. The defendant is the person who the suit is filed against. Pro se means that you're representing yourself. Primary custody and means that one person has the primary time with the children. It could be 4 days versus 3 days, but the 4 day person would have primary custody, or you could have joint custody. Visitation is when one parent has the primary custody and the other has visitation. Legal custody and physical custody are two different things that we're going to eventually cover. Legal custody means that you are making the major decisions about the child's life. So the minor children. So if you have joint legal custody, both parties involved, both parents, need if you have joint legal custody, they both are involved in the major decisions like education of the child, doctor's appointments, health of the child, religion, they both get input into that. If you have sole legal custody, then you get to make all the decisions. But a lot of times it's going to be joint legal custody. Now, physical custody means who the child is with at a particular time. That's who's exercising physical custody at that time. So, as I said before, a parent, a relative, a person, an agency or an organization or an institution claiming a right to custody can file for custody. Someone who with a relationship to or with the child. Where do you file? Look at the district court that you are living in or the county where the child and the other parent reside, the other party reside. So here I am in Winston-Salem. If I was going to go file for custody and I had minor children in this county, and let's say the other parent lives here in Forsyth County as well, I would go and file in Forsyth County Court. If I am looking to file and the kids primarily live with my spouse or estranged spouse or ex-spouse in Wake County, then I would have to file in Wake County, most likely. Generally, you file at any time after separation, but to file in North Carolina, the child needs to have been a resident of North Carolina for at least 6 months before you file the custody action for the court to have jurisdiction. Now, if that child is younger than 6 months, it's going to be, that the child lived in North Carolina for the majority of his or her life. So if you're filing regarding a 4-month-old and you've lived in North Carolina for the whole 4 months, then you file in North Carolina in whatever county the child has lived in. Parental rights in general. Basically, in North Carolina, until a written custody order exists, both of the parents have equal rights to a child. So law enforcement is not going to help you retrieve your child from another parent unless there's a court order in place specifying them to do so. So let's say that the child's other parent is not letting you see the child. You can't just call law enforcement and say, my child's parent is not letting me see the child. You have to go to court and file for custody in order to sort of determine where the child is going to live and who the child's going to be with and what all of that type of information that a custody matter would resolve. Now, if your parental rights have been terminated, let's say that through DSS or something like that, you do not have a right to sue for custody. Now, child support and child custody can be litigated separately. So let's say you don't have a child custody um, order in place yet, and it can take a while to get that done, or you haven't even been able to file yet. You can still go to child support enforcement or on your own filed for child support, showing that the child, where the child lives, and child support enforcement helps you with all that. This presentation is not going to cover that, but those don't have to be done together. They can be, but they don't have to be. So now you're looking at what you're seeking. Joint custody. Remember, I said, both parents share custody, make major decisions about the child's life, and the child primarily resides with one parent usually. It can be equal. It could be week on, week off. It could be 3 days, 4 days, 3 days. I've seen all kinds of different configurations to make things as equal as possible. Exclusive custody means one parent has custody and makes the major decisions if it's exclusive legal custody and the child lives with one parent, but the other parent usually has some contact or visitation. And visitation is when the non-custodial parent has the right to see the children for an amount of time and type of custody determined on ages, how close the parents live to each other, and it's usually on a specific schedule in an order. Before you file, look at this. Why are you filing? You don't need to file to get child support, welfare assistance, school enrollment, medical insurance, or temporary child care. If that's why you're filing, you don't have to do it just for those things. You can do those things separately from the other parent. Now, drawbacks to filing, it can be time consuming. There are a lot of times you have to go back to court for everything. The court examines your personal life, your employment, your mental health, the criminal record, character, who your significant other is, if applicable, all kinds of things that you might not want the court to probe into because the judge is looking at the best interest of the child. It can also, if you file for custody, all of a sudden, that other parent who's been leaving well enough alone and you haven't really been interacting with them, or you let them see the child every once in a while when they call and say, "Hey, I want to see Susie for a few hours today to take her out to lunch." Now, all of a sudden, you file for custody, and the other parent is like, "Oh, well, now I want to get involved." Also, you got to keep in mind that the court's not always going to do exactly what you want the court to do. The court is determining the best interests of the child, not what the court deems as the best interests of the child, not what mom wants, not what dad wants, not what grandma wants. None of that. It's what the best interests of the child are. So when you're filing and in the process of filing and thinking about it, you're going to want to look at, your employment, if you've had any criminal charges in the past or are pending, driver's license, living situation, mental stability, prior court orders. If there are, say, a domestic violence protective order in the case between the two parents, that might be relevant. And look at whether you want custody or just visitation, not just visitation, but look at examine what you're looking for. Do you want to just have a schedule where you see the children every other weekend or on some other schedule? Or do you want to, really be involved in the legal part of raising a child where you're helping decide about the education and all of that kind of thing? You got to sort of figure that out in your mind. Now, when do you need a lawyer in a custody matter? Ask yourself the following questions. Will the other parent be cooperative, or are they going to fight everything? Is the other parent likely to get a lawyer? And if the other party gets a lawyer, will you be able to get one? Will you be able to afford one? You definitely should get a lawyer, if at all possible, if your custody case is contested and the other side has an attorney, or after reading the entire packet for filing for custody, you feel you need help with the filing. There's nothing wrong with trying to do it on your own, and then getting an attorney later on. This is for initiating that custody action. Um, so if you file it on your own and the other side ends up being a lot more aggressive or argumentative than you thought they would be, you can get an attorney at any point in the process. Now, the roadmap to filing for custody. You're going to complete these forms that we're going to talk about. You're going to file the forms with the clerk of court in the district where you're filing for custody. So let's say it's, like I said, Forsyth County. You're going to go to the Forsyth County clerk of court and be ready with your forms and file there. You're going to serve the defendant, and then we'll talk about mediation in court. That's kind of the process. Now, in order to be ready to file for custody, there's a lot of papers. And I don't know if you have, on our website, there's access to a custody packet that is designed for people who are filing without a lawyer. There's a packet for people who are parents of the child, and there's one for some people to file who are not the parent of the child. Like I said in the beginning, there's two different standards for a parent versus somebody who's not a parent. You need to make sure that the paperwork that you're filling out is either typed or is in black or blue ink. That's very important. You don't want to have your cute purple pen to fill this one out. You're going to need an original plus 2 copies of each form. That's because you're going to have one copy for that goes in the file in the courthouse. Then you're going to have one copy that you have to serve on the defendant. And you're going to want to have one copy for yourself. Some counties, you need to know about your county, may require additional forms. And you can go to the NC Courts website, which is nccourts.gov, to access the forms. And it lists the forms that you need. Civil summons, along with the form number. So if you go to NC Courts, you could just type in those file numbers or the name of it. Complaint for child custody visitation, domestic civil action cover sheet, service members civil relief act declaration, affidavit as to status of the minor child, and an optional petition to proceed as an indigent. Now it is a little different, I think, in the counties that have the e-filing system in courts. Forsyth County is about to get it. We're one of the last counties. So if you are in, Wake County or Guilford County or most of the other counties in the state, you're going to want to maybe figure out what the process is for filing electronically. Again, here's the NC State's website, a screenshot of it, and you can type in here the keywords for, custody, or you can search for the form number. Now, that optional petition to proceed as an indigent, let's say you can't afford a filing fee to file for custody. You can use this form to request a waiver of the filing fee to file. So are you receiving food stamps, SNAP, temporary assistance to needy families, or SSI, not Social Security Disability, but SSI, which is needs-based? Or are you represented by legal services? You just provide proof of one of those things, and the clerk should allow you to file without a filing fee. If you don't meet any of those criteria, you can still fill out that form and explain why you're not able to afford the filing fee, but it's in the discretion of the clerk. You need to prove that your case to the clerk if you don't fall into one of the first categories. Do not lie on this form. You are signing this form under penalty of perjury, and you could be held in contempt of court for giving false information on the form. So let's say you have food stamps, you show them a food stamps card with your name on it, but you actually got terminated from food stamps or SNAP 3 months ago. You're not currently receiving food stamps, so you really can't say that. The form has to be signed and dated in front of a notary. Here's the form itself. Um, Petition to proceed as an indigent. You're going to file right here that you want the petition to, you are petitioning to assert claims, and that you're filing a petition to file motions. Those are the ones that you want to file because you want to be able to say that you cannot afford to file or pay the filing fee. And then you're going to check which box applies. I am presently a recipient of SNAP, Temporary Assistance for Needy Families, or SSI, which is Supplemental Security Income. Or I am represented by a legal services organization that has its primary purpose of furnishing legal services to indigent persons. And then you have it sworn in front of a notary. Civil summons. That is the form that you use to serve the defendant. And serve means let the defendant know officially that there's a lawsuit against them, that you're handing them the papers, not you personally, but they have received the paperwork for the lawsuit. And that civil summons is the first form that says that you're filing this lawsuit. Here's the example of the civil summons form. You're going to fill out all the necessary paperwork and file that, make copies, of course, once you filled it out. The complaint. There's a sample located in the pro se packets that I talked about before. They're designed to be self-explanatory. Leave no blank pages unless you're sure it does not apply to you. This complaint has to be notarized. It's called a verification, and you're basically saying everything in this complaint is true to the best of my knowledge. You're going to need the original and 2 photocopies, and you're going to fill in the county, your name as the plaintiff, and the defendant's name. You're going to go through the complaint form and fill in the county where you live, the county and state where the defendant lives. Check the box which explains your relationship to the defendant, and fill out the full names of the children involved in the case, including their current age and date of birth. Excuse me, I need to take a sip of water. There's a space for each child, and you need to fill it out for each child, and I think it includes spaces for 2 children, maybe 3, I can't recall. You're just going to want to make copies of that page for any additional children. And fill out the boxes accordingly. For each child, fill out where the child has lived for the last 3 years, including the address, name of the individuals the child lived with at that current address, and then the current, or at that past address, and then the current addresses. You're going to check the boxes concerning other litigation or lawsuits concerning custody of the minor child. Let's say that you just went and had a domestic violence protective order granted involving this minor child and the other parent, and this protective order grants temporary custody to one or the other parent. You're going to need to reveal that in these boxes, and that's because the court needs to know what else is out there. And also, if there already is a custody action in, let's say, another state or something like that, you have to reveal that as well. You can select the box for custody and or visitation. Number 7, leave it as is. Number 8, select the appropriate box to show grounds for proper jurisdiction. Then there's the prayer for relief, the wherefore. Select the box that is applicable for custody or visitation. Now, do not sign and date this complaint until you're in front of a notary. And then you sign the complaint and include your printed name, phone number, and address. Let's look at the form. Here's the form. So you're going to say where you are a resident and citizen of whatever county in the state of North Carolina. The defendant is a resident and citizen of whatever county in the state of whatever state. The parties are either married but living separate and apart, are divorced, or have never been married. And then you list the children here. And then you fill out, this is the box I was talking about for the first child. who they've lived with for the last 5 years, second child. You're going to just want to continue copy these 2 pages right here for all the additional children. And then this is where you reveal if there's another custody matter out there, or if you know of a person listed below who has claimed custody. And then you're asserting that you're a fit and proper person to have custody, and the court has jurisdiction to hear this custody case because the children have lived in North Carolina for the past 6 months, or the children are less than 6 months old and have lived in North Carolina since the child's birth or a majority of the child's life. You have to have those for North Carolina courts to decide custody. And then you check one of these boxes. This is the verification we talked about. You're going to sign this in front of a notary with your printed name, telephone number, mailing address, city, state, and zip code. And then you're gonna the notary is gonna fill this out, the notarized part where they attest that you have signed it. You have to fill out, in addition, even though you've just gone through where each child lived and who they lived with and what their name and date of birth are, you still have to fill out an affidavit as to status of the minor child for each child that you're asking for custody or visitation of. They look like this, and you're just going to fill that out completely, kind of duplicative or repetitive of what you just put in the complaint, but you have to do this for each child because you're swearing for each child the same thing. So just follow those instructions and fill out what is applicable to you. And then there's finally a domestic civil action cover sheet. Well, not finally, there's another form. Under the state of North Carolina, you're going to write the county where you plan to file, name and address of the plaintiff, name of the defendant, and check the box next to yes, next to summons submitted. That's the first form we went through. And then under the domestic civil action cover sheet, select initial filing because this is the first time you're filing this lawsuit. No, next to the jury demanded. There's never a jury in a custody matter because it's the best interest of the child. According to the court, it's not who anybody likes better or, somebody who thinks that one parent or the other should always have, primary custody. It's a judge who knows the law. Under the type of pleading, select complaint. And under claims for relief, you're going to select custody and or visitation. You're going to sign and date the form at the bottom, and original and 2 copies. Remember, we said an original is for the clerk to keep in the court file. 1 copy is for you and 1 is for the defendant. This is the civil action cover sheet. It's just required for every kind of lawsuit filed in civil court. There's different kinds for different kinds of civil cases. This one is for domestic cases, which are also known as family law cases. Custody mediation cover sheets are county specific. The form is used by the mediation office to schedule an orientation and mediation session dates. You're going to fill out all the relevant information and sign and date the form. This is an example of a custody mediation cover sheet for Robeson County. I don't even know if all counties have them, but if your county has one, you're going to need that. This is so they know how to get a hold of you in order to schedule mediation. Another form, final form that is needed is the Service Members Civil Relief Act. You have to fill out an affidavit that says whether the other party, the defendant, is a member of the military. So that's Army, Navy, Air Force, Marine Corps, National Guard on active duty. You have to fill this out because there's a federal law that says that service members have their legal rights protected during active duty. So you have to swear that the defendant is not in the military. If you don't know, you can use this link here at the bottom of the page and search the defendant's name in that. Or let's say you've been married or in a relationship with the defendant for 8 years and they've never been in the military in the 8 years preceding this action, you can write that in there as well. Or you could do both. If you're filing against a service member on active duty, the court can't enter an order until the court appoints an attorney to represent the service member. In most cases, if a party is on active duty, the case is going to be stayed or postponed until a later date. That's because it's just not fair if, say, somebody is deployed overseas to proceed in any sort of civil action against them without them having to be having their chance to be heard. Make sure this is filed and complete in your case. There are a lot of judges will dismiss a case, and they should if it's not filed with it. So, or deny the relief that you want. Here's the Civil Service Members Civil Relief Act Declaration. This is where you're asserting that you are telling the truth about this. It is not a notarized form, but it is under penalty of perjury. Okay, now you're going to take the original and 2 copies of each document to the clerk. Original is for the court, 1 for the defendant, and 1 for you. You're going to pay the filing fee or ask to have the petition to sue as an indigent approved. Ask that copies of the summons be issued by the clerk and have the sheriff's fee ready. Depending on the county, some clerks are going to forward this information to the sheriff. No, I think that in this kind of case, you have to bring it to the sheriff yourself for service. The clerk's going to file stamp copies of the summons and complaint and mark the papers with a file number. That's your number from now on. So you're going to have to remember that number or look it up. So if you ever file a motion or anything else in it, it's always going to be under that number. The clerk's office will not accept personal checks if you're having to pay the fee. You must use cash or money orders, or I believe you can now use a debit or credit card in most counties. Remember that clerks are not lawyers, so they cannot give legal advice. They can't tell you missed a form, or, I mean, they might, that's not exactly legal advice, but they can't tell you how to fill out the forms or what the proper way to fill it out is. They are not lawyers. Now, to serve the defendant, we've talked about serving the defendant, and that just means that you're getting a copy of this information to the defendant so they know that there's a lawsuit and they are ready to answer the lawsuit. You can't serve the defendant yourself, and your case cannot be heard without proof of service of the defendant. There are several ways to serve. There's a sheriff, the primary ways, and certified mail. We'll talk about the sheriff and the certified mail. Publication, you're probably going to need an attorney at that point. That means you can't find the defendant. You've tried every single possible way, and there's a process to it. So I don't know that I've really ever seen a pro se, somebody representing themselves, in other words, do a publication. Service by the sheriff, cost is $30 per defendant. If you're I know that in a couple of the counties I've practiced in, the clerk files the summons and then might write indigent at the top if that petition for indigency is granted. And sometimes the sheriff will waive that cost, but you're going to need $30 cash or money order, or the sheriff in Forsyth County does accept cards. $30 per defendant. You're going to give the file stamped copy of the complaint and summons to the sheriff, and the sheriff will notify the court when the service is effected. In other words, when they've been able to give a copy properly to the defendant. Certified mail. You can do it this way as well. If the sheriff is unable to serve a defendant, you know where the address is. You take a copy to the post office, and you're going to have a big envelope with the papers probably, and you're going to ask for certified mail return receipt requested and do what the post office says about how to file that. When your green card comes back to you, you're going to fill out an affidavit of service by certified mail and attach the green card and sign the affidavit in front of a notary. Make a copy for yourself and give the original to the clerk. This is the affidavit of return of service by certified mail. You're just saying that I served the person this action. Here's the address, and here's the return receipt, the little green card that shows that they received it. What comes next? After you file this, the defendant has 30 days to answer. Now, in a custody case, there's not such a thing as default. So even if a defendant doesn't answer, they can still come to court and participate in the case. So the defendant has 30 days to answer. They can do nothing or make a motion for extension of time or answer with or without counterclaims. If there are counterclaims other than custody or visitation, consult a lawyer. So let's say that the defendant says, okay, I've got this, and I am also asking for primary custody for these reasons, but I'm also asking for, we were married and I want divorce and equitable distribution as well. Well, those are things that you might want to ask for or consult with a lawyer about. The case is automatically set for mediation, and mediation is, we're going to talk about it next, but the court will provide instructions for you and the defendant both for mediation. What is mediation? In custody cases, this is a process in which professionally trained third neutral party helps the parties develop an agreement for the care of their children during and after separation. The goal is to give the parties an informal forum to discuss parenting issues prior to trial. This is great if you're on the same page about most everything. If you both agree or mostly agree, that mediator can help y'all decide. The two parties decide, well, this is a baby, and so they're not in school yet, so we want to do, this kind of visitation or this kind of, custody schedule. They guide you through that. No attorneys are involved at this point, even if either party has them. So it's fantastic for being able to hopefully work through things in a non-adversarial manner. There's an orientation session followed by an informal confidential meeting or meetings with the mediator. The only document that leaves the meeting is the parenting agreement, if there is one, reached through the process, or the mediator lets the court know the parties were not able to agree on a parenting agreement. That's what happens. Let's say here's a standard visitation schedule. Let's say every other weekend with alternating major holidays: Easter, Memorial Day, Mother's Day, Thanksgiving, Christmas, 4th of July, spring break, and 4 to 6 weeks in the summer. The mediator can suggest what to consider in making the parenting agreement, but they're not trying to weight it one way or the other. They're there to help the parties agree. If mediation fails, you ask the clerk in charge of setting hearings to give you a hearing date and follow the directions from that clerk. File a notice of hearing and calendar request, and serve the defendant with filed copies of both forms. Keep track of all your court dates. That's your responsibility, and be on time. If a case is set for a custody hearing, you're going to gather witnesses who can testify about your ability to care for your child and evidence that supports your claim that you're providing the best home for the child prior to the hearing. You're going to want to get all that in order. Here's a sample of a civil calendar or a calendar request in Alamance County. Each county has one of these calendar requests. If you can't find one for your county, you can use this as a rough guide or ask the clerk. Let's say you're getting close to the hearing, or you're not even close to the hearing, and you're just decided, you know what? I don't want to go through court. I want to wait and do something else. You can file a notice of voluntary dismissal of your custody complaint. That stops the trial. This is gonna, before there is a custody order in place, and you can file it using the same grounds for up to a year later. You're only going to want to dismiss if it's really necessary for some reason. I can't even think of reasons, but be aware that if the defendant filed counterclaims for custody, those still stay alive even if you filed a notice of voluntary dismissal, unless the defendant also dismisses their claims. Here's some tips for preparing for trial. Dress conservatively in as professional attire as you can. That doesn't mean you have to wear a suit or a dress, but you want to wear, nice clothes that you feel show respect to the court. You want to make a good impression. You want to be on time. You're not going to use any drugs or alcohol before or during a trial. Always tell the truth and try to maintain your temper and composure. These cases are hard for that. You're going to want to remember to stay cool, calm, and collected. I tell when I've had custody cases in the past, or even in domestic violence protective orders, but especially in custody, I'm like, remember, you want to look like the reasonable party. You want to look like the reasonable parent. You don't want to roll your eyes when the defendant is testifying. You don't want to make noises like, oh, while they're testifying. You got to stay cool, calm, and collected. And that's hard to do, but try to remember you're trying to show the judge that it is in the best interest of the child that what you are asking for is granted. The judge is not deciding who they like again. They're deciding on who is the best interest of the child or what is in the best interest of the child. Obviously, if you're calm, that's going to look better than if you're angry and disrespectful to the court. After the hearing, the judge may make a decision verbally or write out a decision and mail it to you. The judge's decision is called an order. You must comply with this order as it is written, no matter what your feelings about it are. Remember, we talked about, having an order that might not be what you wanted. Doesn't matter. It's now an order of the court. If you violate the order, the court can punish you by holding you in contempt of court. Now, modification of orders are sometimes necessary. So you might file a motion to modify. Let's say it's a temporary order that's just sort of a temporary order that holds the place until you can have a more permanent hearing. Sometimes they're shorter. Some districts require, have time limits and allow affidavits in the temporary order, but the big permanent hearing, you need the witnesses. Let's say there's a temporary order in place and you want that modified. You file a motion to modify, and the judge decides whether it's in the best interest of the child that it's modified. But let's say that it's considered a permanent custody order or a parenting agreement that you've mediated together. You're going to require showing a substantial change in circumstances to change that initial order. For instance, let's say you're sharing week on, week off of a infant, toddler, and then all of a sudden they're getting ready to start school, and one party or the other has moved a county away. And you can't agree on where you want this child to go to school. You might have to file a motion to modify because the change in circumstances is that the child is starting school. That's a substantial change. It's not just, I didn't like the first order and I feel like the judge shouldn't have done that. It has to be one of these reasons: best interest of the child or substantial change in circumstances. We've got a helpline, and our website here is, I'm going to leave it here for a minute so you can copy it down if you'd like. And there is a lawyer referral service through the North Carolina Bar Association where you can have a 30-minute consultation with an attorney for $50. So you can at least get an idea of where maybe you want to go with a lawyer, or maybe get just some quick advice about, I want to modify this. Should I do that? So those are the resources. I'm going to leave them there for a little while. Again, now I guess we're going to go to questions. And I'm going to stop sharing my screen here in a second. So, Marissa, how long should I keep this up?
You can stop your share already. I put a link to the North Carolina Law Referral Service in the chat box. I'm also going to put a link to legal aid here in a second. So you can go ahead and stop your share if you want to. Um, and then we're going to get
If
into the
anybody wants me to
questions.
share that with them again, I'm glad to do that.
Perfect. So, quick thing before we get into questions, please, like has been stated, this is a public
So
forum. Keep your questions general, as well as
I see
you
there's maybe
cannot.
some questions in the
Well,
chat.
hold up. Can you not hear me, Monica?
Um,
Ooh, hello.
well, it looks like Marissa added a lot of helpful links on the side. So there's a question and answer box as well. So I'm going to click on that and see if I can answer some questions. Okay, first question is if a relative that you do not have a healthy relationship has placement of children due to a 12-hour emergency non-secure custody petition, excuse me, filed by CPS, how do I appeal appeal the decision? That is beyond the scope of this presentation. This is about initiating a custody suit. So I am not going to be able to answer that question. Um, What if you don't have addresses to serve your grandchild parents? You have to be able to get them served. The other option is that publication that we talked about, and that is generally you're going to need to have an attorney involved in that because you have to make certain showings that are required before you can go to publication. Publication means that you're just basically serving it by some sort of newspaper or other publication. And it's a last resort because the court really does want the input of the all the parties if they're able to do so. So that is you always have to try to serve the other party. I don't know if a copy of this Zoom will be available later. I know we have several on our website. So Marissa, can you answer that one?
Yes, can you hear me? I don't know if you can hear me.
How do you transfer sole legal custody to another state? That's a question you're going to probably also have to consult with a lawyer about. There's motions to transfer venue. Usually you're going to go to the original state and ask for a motion to change. You're going to have to show whatever rules are required in that state and the new state that nobody lives in that state anymore or something else, but generally you're going to need an attorney's assistance with that. How do I correct appearance of impropriety? I'm not sure I understand that question. If you want to yeah, Marissa, thank you. And yeah, I can't hear you when you talk. Thank you for answering that question. So I'm not sure about the appearance of impropriety. I'm not sure what you're asking exactly with that. So if you want to expand on that, I will try to answer it if I can. If not, then um, I will, but I just don't understand what you're asking about. Is there an opportunity to meet with the mediator individually before mediation? Generally, no. You're going to meet together. That's the whole point, is to be able to have a neutral party that's not convinced by one side or the other ahead of time. I've contacted legal aid and referral service. Is there additional assistance? I am not aware of assistance out there. Unfortunately, legal aid is generally not able to provide representation in custody matters. Um, and the referral service is just for a, brief consultation. Um, Unfortunately, I don't know of a lot of places that provide um, low cost or no cost custody representation, as far as attorneys go. There may be individual places like in some of the larger counties that do that, but I am not aware of any at this time. Um, if there is no parent on the birth certificate, what rights do they have since they've been absent for 4 to 5 years? If you know who the other party is, um, well, if they're not, this is one of the things that we talked about in the initial part of to consider when to file for custody. Um, and one of the drawbacks, remember, was that if there's somebody that's not involved at all and you file, that could get them involved. But if there's a reason that you need to file custody, for whatever reason, um, the parent, um, I'm not going to say they don't have rights, they do, but um, if they don't have proof, excuse me, my battery's running low, so I am going to plug in my computer so I don't lose you all. It's right here. Apologize. Um, so still though, if they assert that they're the parent and want to all of a sudden come into the child's life, that might be a reason to file for custody, but that's one of the reasons that you might not to decide not to file for custody. Um, this is a question. I've temporarily moved to another county. My child support is in my parents' county. Should I still apply in my county even though I won't be here for 6 months? So are you trying to get child support or are you paying child support? That could change my answer. Um, they took my visits because the father of my child went into one of our visits. That is a very specific question that I'm not going to necessarily be able to answer. You're probably going to want to comply with whatever the judge has told you to do and possibly file a motion to modify, if it's a permanent, whether it's permanent or not permanent, order. That's the only way I know of. Just definitely follow whatever the judge has directed you to do. And when you show that you have, then file a motion to modify. But I can't give you specific information about that. Where would I find information about adopting a stepchild? I am not sure about that. That's beyond the scope of this presentation, unfortunately, so I am going to have to decline to answer that one. During a custody battle, can CPS get involved when one's past is looked into? Anything's possible. I have seen court personnel that everybody's a mandated reporter of suspected abuse. So if something is brought out that's concerning, somebody could report it. I can't guarantee that that wouldn't happen. So once it's a public document, it's out there. If you have an agreement settled in mediation, is that logged with courts, meaning that has to be followed by law? As part of the mediation process, the process is that you come up with that parenting agreement, which is signed by the court and becomes a court order. Yes, that is in fact the case, and it has to be followed by law. Okay, you're getting child support. I'm not really sure about whether you should file in the new county or not. That's a little beyond the scope. My advice is always go to the child support enforcement and ask if it's under child support enforcement. If you're short term, I don't know what the answer is, but ask them if that's who's doing it. If it's through if it's a court order that's child support and custody, then if you're only temporarily in an area, it's not likely to need to be changed. But if it's child support enforcement, I would just ask them. Is there any additional assistance for CPS, DSS versus parental custody? We're not able to assist with CPS, DSS, custody proceedings where CPS or DSS has filed something. We just can't give advice about that. Let's see, my son is 15. We have started 50-50 custody against his mother's will. Now I'm being sued for custody and legal fees. I now have a home and quit traveling for work. How much weight will the judge put on my desires? I can't give specific advice, but there's a certain age, around 14 or so, where a judge will consider a child's preferences to a degree. They still have to go by best interest of the child, but usually want to hear from that child what their input is. How do courts typically rule when it comes to an absent parent coming back into a child's life? Daughter 5 met dad 11 times total, now demanding rights, does not pay child support, not on birth certificate. That's going to depend on the court. You can file for a custody suit if you wanted to make the court decide, or the defendant or the other parent can file a paternity action. So it's just going to depend on what you want to do. Remember I said that if everybody's kind of acknowledging that he's the parent, it is possible that law enforcement would not assist you if he had the child and wouldn't give the child back. I just don't know. That's up to law enforcement. Basically, that's one of the things that the court weighs in best interest. These are all factors. How long has the child been absent, or has the dad been absent? What's been happening in that time? Parents do have a constitutional right to be a parent, and it's up to the court to decide whether the parent has acted inconsistent with that. So I can't tell you what the judge is going to do with that, but it will be considered. Make sure that you ask your questions if you have them. Okay, please note that Marissa posted in the chat the link to the or there's a message about accessing the recording later, and that there are no questions on Facebook. So unless we have another question, I am going to close this session out. I thank you so much for joining us today, and I hope that you've gotten information that will help you in filing for a custody or visitation action. For specific, like I said, specific legal advice, you're going to need to consult with an attorney. Legal aid does not represent you in your custody matter. And this is very general advice given to a number of people. So thank you again for joining us. And I will terminate the session here.